Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend, special guest, Russ Cook with Russ Cook and Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney, and we were talking a little bit about probate beforehand and how the time involved, typically about 9 to 12 months to go through probate. So, understanding again, to recap that, if you have a will or if you do not have a will, you go through probate. A way to avoid probate would be with a revocable living trust as an example. However, there's some important steps that have to be followed there as well to make sure that's going to work. So one of the things that we get into when we're talking about probate, we've talked about the time it takes to administer, again about 9 to 12 months, and that's if everything goes smoothly. Okay, if there's any kind of challenge to the will or any kind of dealing with creditors, that could delay that time frame, and then you can get into additional costs as a result. The longer something takes when it comes to that, of course, the more expense. And the other is on that cost. We were talking about a number is like $5,000. Well, that depends on the size of the estate. It depends on how complex things are. It also, of course, depends on the attorney and the county. It could easily be multiple times that. You could be, easily 10, 15, 20,000 or more, depending on those types of things. And then there's privacy issues with probate. Everything's public, Russ. That's one of the things. Let's talk a little bit about, just briefly. When it comes to the probate, basically there's a disclosure piece. I mean, everything that this person has and who it's going to go to, all that's public record, right?
Yes, and it depends on the type of documents that are used to go through probate. For example, a lot of wills, if they're well written, will avoid having to disclose what the assets of the estate are, unless you're in certain counties where they ask that you give a general total. But a lot of cases, either the will doesn't have that clause or the beneficiaries in a non-will case, intestate case, don't necessarily waive that provision. And so the executor, the administrator, has to file a list of what all the assets are and what they think they're worth. And that becomes public record. So anyone that decides that they want to look into your affairs after you're gone can always pull that file and see exactly what you put down there. There also is an accounting at the end, which is another statement of the assets and how much each person got. And one thing I kind of try to talk clients or discuss with clients when it comes to probate is you definitely don't want to set your beneficiaries up having to defend against charlatans and other folks that might see how much they're getting and decide that they're a target. I mean, there's a reason people don't want to be disclosed as lottery winners.
Yes, exactly. And that's basically it. If you're going through probate, all that's in there. It's got even the contact information if you wanted to get it. So anyone can walk in through and look at probate files. And of course, it's very easy. I've done this. Go down, and they'll point them out to you. You go over and you look, you open up a file drawer, and guess what? Pick the thick files. They typically are going to have more stuff. You can make it real easy on yourself. And then you can see what the money is, who got what, where it went. Great prospecting list, I guess, for someone looking to try to go after, try to get money from someone. All right, the other is so that's one of the nice things with a trust. Of course, you can keep that private. But if you own property in other states, you could potentially be then having not just one probate, but a probate in each state. Yeah, you could, and that could be very expensive, depending on the states that are involved. I know in California and Florida and New York, for example, their probate process is very court intensive, and so it requires a lot of documentation and a lot of expense. And typically when a client comes to us that has real estate outside the state of Tennessee, that's the tipping point. Right. That's when we decide, no, we really don't want to go through probate in multiple states. Well, and that's it. So if I've got property here in Tennessee, and I've got property, say, in Alabama, and I've got property in Florida, I get 3 potential probate cases I'm going to have. I'm going to have multiple costs then with that. I'm going to need an attorney in each state to handle that. So I've really just increased my costs dramatically, not to mention time and complexity. And a trust is one way that you can avoid all that and avoid probate entirely. One of the things when it comes to revocable living trust, and I really like trust for this reason. One, the avoidance of probate, and so my privacy is protected, so I don't have to worry about people knowing, what money went to, how much money I had, who it went to, and targeting those people, and it just keeps it cleaner. The other piece is I don't have to worry about people in terms of challenging. If we're talking about probate, this is a forum for people to come forth and make a claim against an estate. If you've got a trust, this is one area, no one, it's not a public notice put out there. It's not a court case that's been open for that purpose. The time to administer, of course, Russ, this is one of those areas. That's going to be a lot less. You don't have to go through any of those public notices or anything. So what would you say typically for administering a trust compared to that of a will?
Well, it's a much shortened time frame, because as long as your assets are in the trust when you pass away, the trustee takes immediate control of those assets, and that could be very helpful, especially when it comes to paying bills like funeral bills, where the funeral home wants that sort of payment right away. The other is dealing with real estate. We found that if the real estate is in a revocable trust and it needs to be sold fairly quickly because it's a lingering asset, then you can sell it much quicker, because you don't have to go through all those court hoops in order to get
if you want
the ability to do it.
If you've got real estate and it's going through probate, you're going to have to petition the court, right, to get just to be able to sell it prior to the end of probate.
Yeah, if the will is not properly prepared, or you have an intestate estate, depending on the situation, you will have to go to court sometimes, because what the law says is that when a person dies, the real estate they own gets immediately vested in the people that are designated to inherit it. Unlike the personal property, where that has that period in which the executor is in control of it, the real property, the executor technically is not in control of it. And so the reason that you have to go to court and file a petition to sell it by the executor is that they have to gain control back from the beneficiaries over that real property, and that's what that petition does. And that is a time-consuming and expensive process if necessary.
Yeah. And just to be able to sell before the end of the probate period. Otherwise, you're waiting to 9 to 12 months sitting on a piece of property before you can put it on the market, and that may not be getting you the best situation with regard to price of the market, all those kind of things. You want to have more control there. A trust is going to give you more control over those things. So let's talk about a revocable trust. Now with a trust, what we're doing basically, the probate proceeding in essence is getting all these things that this person had over to the beneficiaries, changing title where it's needed, all the different things that go with that. With a trust, of course, we're doing all that in advance. So with a trust now, they come in to get a trust, they're going to spend a lot less than that they're going to have with regard to probate. They're going to have the privacy, but the other pieces from how it works for them, it's a little more work though setting up. A will, you come in, boom, 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 you get that done and you put it in a drawer and you don't worry about it.
Yeah, and that's a big concern for us, because whenever we have revocable trusts, the whole idea of having the trust, and you're paying more for it up front, there's more involved, is that you want to fund it while you're living. Basically, you're stepping into the shoes of who would be your executor, and you're taking the process on as transferring the assets that you own into the trust. And a lot of times we'll see where someone has passed away, they had a revocable trust, and maybe the only thing that they decided to put in was the real estate, because the attorney did it.
Did that, right.
And the financial advisor was left out of the loop, or maybe there wasn't a financial advisor, or someone just dropped the ball, or the client decided not to do it. And they don't fund the trust with the rest of their assets, and as a result, we're going through probate, even though they tried to avoid it.
That's one of the areas when it comes to who you're working with. Like one of the things with my clients, when we go through estate planning, and I work with Russ and we're setting up an estate plan for them as an example, get the trust done, Russ takes care of the real estate. Now when it comes to the other assets, different accounts they might have, savings, checkings, other property and stuff, well, personal property is handled, by the way, within the documents as well. So I'll deal with all the financial stuff and with my clients and make sure that those get properly titled into the trust or with the trust named as beneficiary. And then when we do reviews to see how their plan is, we're always making sure if they acquired a new asset or if we're making a change on some assets, that we stay consistent with that and that we keep that trust fully funded so that the assets that you have, they're in the name of the trust. And that doesn't change how you do things. It doesn't change your day-to-day, operating of and handling those accounts. It doesn't change how you do your taxes, none of that, okay? It's only there in place, so when you're gone, or if you became incapacitated for that matter, the things that you wanted to have happen are going to happen, and that we're not going to have to, as Russ was saying, if you didn't do that, now you've set up a trust, you got some properties handled, but guess what? It's going to go through probate anyway. So, just because we didn't take the time to get that handled, and again, with my clients, we make sure that's done, and with reviews, we're able to keep up with it to make sure that nothing changes there, or if there are changes, that they stay consistent to the plan. If a new asset's acquired, it goes in either to the name of the trust or the trust named as beneficiary according to what kind of an asset it is. All right, we're going to take a break. One of the things when we come back, I'll give again out an offer for the first 10 callers to my office. And then we're going to get more into how trusts work, and also some of the new changes with regard to trust law and how that can benefit you and your family. And there's some potential big savings when it comes to taxes, for instance, with some of the new laws there as well. And the asset protection features, which I absolutely love when it comes to trust. This is one of those areas where you can really do something for your family that they can't do for themselves, but you can do for them. This is a great, well, join us here. We'll be right back on the Retirement Report.